After listening to this video, you're going to wonder the same thing I do, which is, what is wrong with the courtroom microphones in Iowa? Hi, Tony DeWitt here. I'm a Missouri appellate attorney, retired, and I bring you a fresh perspective on the law without offering any legal advice. So pull up a chair. This is what we're discussing today. The other day, I went to make a video in the, I believe it's Iowa versus Ali Yunus case, where a man had done something very bad to a young lady and then stolen her earrings. Looked like a fairly simple, easy case to get through, and you couldn't understand the testimony because it sounded like they were talking in an oaken barrel with a microphone at about 20,000 feet. So I picked up a new trial today from Iowa, and this is what I got.
The state wishes to make an opening statement. It may do so now.
Thank you, Your Honor. May it please the court counsel. On the evening of September 22nd, 2024, in Farmville, Iowa, 17-year-old Michelle Jackson was brutally killed in a vicious attack that shocked the small community of Farmville. Through the testimony of approximately 12 witnesses and compelling physical evidence, the state will produce evidence showing beyond a reasonable doubt that the defendant, Nathaniel Kyron Bevers McGivney, committed murder in the first degree and abuse of a corpse as charged in the trial information. Your Honor, we often say someone is caught red-handed to mean they were caught in the act, so to speak. Here, Your Honor, the phrase is grimly literal. The evidence will show that Michelle Jackson's blood was found on the defendant's clothing, on items he was caught removing from the crime scene, including her bloody shoe and a green electric scooter that she had driven to the park that day. And most crucially, on components of a Mossy Oak brand replaceable blade knife that was recovered from the defendant's apartment and person.
Now let's talk a little bit about the prosecutor's opening statement here. You'll notice that he is doing something that I think most people caution against in an opening statement. He's essentially reading his opening statement. Now, it is absolutely okay to write out your opening statement. It is absolutely okay to have practiced it numerous times. And if you're going to give an opening statement to a judge, I suppose it's okay to do it in this manner, where you're simply reading from a prepared text. But you would never want to do this in front of a jury. Now, this happens to be a bench trial. So because it's a bench trial, the judge is sitting up there as both the finder of fact and he has to rule on the questions of law. And so, in this particular instance, he can get away perhaps with a little bit of things that he couldn't otherwise get away with because the judge will determine whether or not what he said was objectionable, if there is an objection launched. But more importantly, he is essentially duty bound to ignore anything that is inadmissible. So as the finder of fact, he has to find the facts, but as the judge on the law, he can't let himself consider facts that he would have kept out in a jury trial. And so that's one of the reasons why it's a little bit more loosey-goosey for a bench trial. I don't think it's ever wise to waive a jury if it's a close case, but in a case where you're talking about a bench tried case, particularly if there is a possibility for a lesser included, like manslaughter or involuntary manslaughter, something like that, sometimes you might want somebody who is a little less subject to being emotionally driven in their quest for justice. Now, a lot of what the prosecutor goes into here in this opening statement deals with some of the more graphic details in that case, and I don't think you need to pollute your mind with that stuff today. If you want to see that opening statement, you can certainly go click on the trial day and find it. But I don't think you need to do that. I think the point in this video anyway is the contrast between the opening statement that's being done by the state and the opening statement that's being done by the defense. The defense is talking to the judge, not reading to the judge. Let's take a listen.
To make a opening statement?
Yes, Your Honor. Smith, Your Honor, the one thing that the state left out in its last part of its statement was premeditation. And that's where the defense is going to ask the court to focus its analysis of the evidence as it comes in, both premeditation and deliberation. Those are two of the required elements for first-degree murder in Iowa. And all of the things that Mr. Smith talked about in terms of how this unfolded, and especially what the court can glean from what happened afterwards, weighs very heavily that this was not a premeditated, deliberate act, that this was a spontaneous outburst, that it was not pre-planned, there were no eventualities made for what would happen afterwards, because there was no forethought given to the act. It was just a spontaneous outburst. So all of the things that Mr. Smith had talked about in terms of the fact that this is a very small town, we're talking about a half-mile square each direction. This is at a centrally located public park on 4 fairly well-traveled roads, just off of where the roads are at, where the public is passing by on cars. We've got decent lighting in the area, especially around the area where this event occurred. It was near a building. The attack happened on pavement, as Mr. Smith talked about. There were large pools of blood. No thought given to a more concealed location. They were easily discovered once law enforcement started walking around the park. We've got these drag marks that clearly show that the body was dragged to the trash can which he was placed in. And that's another thing that the court will hear evidence on from the homeowner who had that can. They just simply had it taken from their home that way. There was no forethought given of what would happen afterwards. We've got other things that you can look at when you listen to the evidence that Mr. Smith talked about with the interactions between Annette Jackson and Shauna Bachman. When they're confronting Nathaniel about the scooter, he has no good answer. He has not thought of what to say in the event that he's confronted. He's giving confusing directions. He's talking about living over in this direction and returning the scooter to the park, but he's not traveling in either of those directions. The scooter itself has a bloody shoe in it. And the point there, Your Honor, if you listen to the evidence, what's going to become clear is that after Michelle was killed and the body was taken over to the Landis co-op, Nathaniel at some point did go home, because that's where the knife was found.
Did you notice what happened there? The prosecution left out the key element in a first-degree murder trial, which is premeditation. You have to have essentially done a little bit of planning. Now, it doesn't have to be extensive. You just have to have had this plan and executed it. But you can form the plan in a matter of moments. Sometimes premeditated killings are spontaneous, but they are still premeditated because you do it and think about it before you do it. That's sort of the whole premeditation thing. So instead of making a classic opening statement where the evidence will be this or the evidence will be that, instead, because he has a legal defense, not a factual defense, he says to the judge, focus on the premeditation aspect. That's what you're not going to see in any of this. It's all spontaneous. It was all acting out of, some kind of spontaneous influence. And as a result, my client shouldn't be tried for first-degree murder, and you shouldn't find him guilty of that. He'll probably be found guilty of a lesser included offense, I'm guessing. Now, at the end of the day, will that be more persuasive than the first opening? I don't know. I doubt it. The defense usually operates in a little bit of a disadvantage in a bench trial because the judge has heard and seen a lot before this case, and he knows how things are done. He knows what all of the I would guess you would call them the tricks of the trade are, and he's less likely to be influenced by good lawyering than perhaps a jury would be. But I would prefer that you don't finish this video thinking about some of the awful things that are mentioned and can instead sleep peacefully in your bed tonight, because that should be what we do with a trial where we don't need to put in all of the gory facts for whatever reason. Whenever you have a trial that involves a homicide, in almost every case, there are going to be graphic facts. And at the end of the day, what matters isn't those graphic facts, it's whether or not the person charged did the crime. And you don't really have to see all that to reach that conclusion. There is a supposition that juries need to see that because they need to see how bad it was. But I still think that's just an appeal to their emotions, not an appeal to their logic. So, at the end of the day, I thought the openings here didn't move the needle either way. But tell me what you think. That's what I have for you today. I hope you found it helpful, interesting, or maybe both. If there's a subject you'd like me to discuss, please feel free to send me an email at the address above. If you like what we do, please feel free to subscribe and come on back to the beach tomorrow. I release videos every weekday, weather and work permitting. If you have the opportunity today, do a kindness for your fellow man. It makes the world a better place, one kind act at a time. And now, YouTube has some suggestions for other videos of mine that you might like.